syndicate.
So if found guilty, you're going to be looking at a minimum 25 years in prison to life. That will be stacked on any other sentence. That is all. That's all.
Thanks, Joe.
He's made his decision. It's going to go to trial. 2025 in Jefferson County, Texas, you committed the second-degree felony of burglary of a habitation. Do you understand what you're charged with?
Yes, sir.
This is a second-degree felony, which means you face no less than no more than 20 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand?
Yes, sir.
Yes.
Yes, sir.
Okay. An agreement's been reached where you would be pleading guilty, not found guilty. You would be placed on deferred or unadjudicated probation, which can be up to 10 years in length. And another case will be dismissed, 25 CR 1056. Is that your understanding?
Yes, sir.
If I follow this, you have no right of appeal. Do you understand?
Yes, sir.
How do you plead to this? Guilty or not guilty?
Yes.
You're pleading guilty voluntarily. That is on your own free will. And because you are guilty. Yes.
Yes, sir.
That's a question. Are you on your own free will and because you're guilty?
Yes, sir.
Okay. Show you what's marked as State's Exhibit 1. Did you sign that? Understand it? Discuss it with your attorney? Are the contents true and correct?
Yes, sir.
State's Exhibit 1 tendered?
No objection.
Without objection admitted. The states you are mentally competent. Entered your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged and any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with representation by your lawyer. All true. So help you God.
Sir?
All of this is true. So help you God.
Yes, sir.
State's Exhibit 1, part of the record for all purposes. Pre-sentence report is waived.
Yes, sir.
I will follow this agreement. I'm going to find that you are pleading guilty voluntarily. You are mentally competent to do so. There is sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. But I'm not going to find you guilty. I'm going to place you on deferred or unadjudicated probation for 10 years. There will be terms and conditions of probation, which are normal and customary for this type of offense. Make sure you follow this. If you fail, your probation can be revoked. You can then be found guilty and sentenced up to 20 years in prison. You don't want that, do you? No. There is no restitution, I guess, right?
That's correct, yes.
Okay, you're going to see the probation officer. There's one other case, 25 CR 1056 will be dismissed as part of this agreement. Do you understand, sir, what has happened today?
Yes, sir.
All right, please see the probation officer. And
He's saying that he wants to go, I made him aware that the state intends to enhance 25 to life. And he's saying that he does want to go to trial.
okay,
I gave him the police report, I gave him the indictment, and I also gave him the plea offer, 8 years that he did.
Yes, sir. And he was only talking 15 minutes.
The unlawful possession of a firearm by felon, that is the one that he's gonna go to trial on with you.
Mhm.
And you're saying that you don't want to take, I guess, right?
So that was all.
All right, so we're gonna do that.
okay. Yeah, he was intoxicated, right? Is what it says, and they find a Taurus in the glove compartment of his vehicle. And
Don't worry about it.
Mr.
he has 4 prior convictions of DWIs. And looks like he was. Now, okay, that's okay. You're not eligible for probation in front of a jury, and this gets, they're looking at, you're going to indict as a habitual felon?
Yes, sir. My records indicate.
So if found guilty, you're going to be looking at a minimum 25 years in prison to life. That will be stacked on any other sentence.
So
That is all.
So you sure?
That's all.
Thanks, Joe.
He's made his decision. It's going to go to trial.